I've been working with Indigenous communities to identify law from stories as well as from practices and from legal cases, historic cases. And I've been working with Emily and with Hadley and some other students on this project. So I take the position that Indigenous peoples need to have effective legal pedagogies because Indigenous legal traditions need to be a part of Indigenous self-determination, rebuilding our citizenries, and form part of the basis for Indigenous peoples relating to each other and to state governments locally, nationally, and internationally. I think that Indigenous legal traditions is one way to build a public Indigenous intellectual life. So to do this, we need accessible and practical ways to substantively articulate, apply, and teach legal traditions. And it's about managing ourselves, it's about solving problems, and it's about managing internal and external conflicts. So when thinking about Indigenous legal traditions or any other law, whether we're community people or academics or practitioners or students, whoever we are, it's the work demands that we look at its structure, the structure of the legal traditions, the logic, the operation. So it's moving beyond practices to what gives the practices meaning and looking at different interpretive approaches. It means, to build on Hadley's presentation yesterday, moving from the abstract to asking what are the legal concepts and categories in the different legal traditions, what are the principles, what are the legitimate processes or procedures for collective decision making, and what are the ways that people reason through the issues. So what's demanded then is a serious and sustained engagement with Indigenous law. And it's that sustained and serious engagement that actually creates it over time. So this is drawing on the work of Bruni and Toop, where they work with Fuller's theory to develop and advance international law on an interactive kind of basis. So by the same token, arguably, if law is created by sustained and serious engagement, then a lack of serious and sustained engagement can cause law to lose its legality and its legitimacy, and that law can actually cease to exist. Or it can cease to exist in its fullness, and I think that's where we start to see problems of distortions of Indigenous law, but also I think it leads to the invisibility of legal obligations that underlie contemporary expressions of people trying to fulfill those legal obligations. I think that that's why the example of the banishment, for instance, would be one where a deeper conversation needs to go on around those kinds of issues. So the methodology then that we've developed is, when working with Indigenous legal traditions, we've been consciously, self-consciously applying an adapted common law methodology, which means case laws method, it means legal analysis, it means legal synthesis. So the intent is not to displace or to supplant other kinds of pedagogies, but to supplement what's already going on. So the legal pedagogy that we've been employing is about re-examining how Indigenous peoples and Indigenous elders are using stories as tools for thinking. Now, arguably, this is what state law does. State law tells stories through cases. Cases are opinions about what happens. It takes precedential information and applies it, and then out of that there's an application of law that then forms part of the precedential record.